What would you say is the biggest mistake you see when it comes to handling inheritance in divorce cases?
Definitely using it for...
Hi, everyone. This is the Illinois Family Law Insider Podcast. I'm Katie VanDeusen, a managing partner at Sterling Lawyers. And with me today is Reyna Herrera. She's an attorney who just recently joined our team. And thanks for joining me today, Reyna.
Yeah, happy to be here.
So, Reyna, today we are going to dive into a really, I think, interesting topic, which is what counts as marital property in Illinois and what doesn't. So, in terms of talking about this topic and what it means in certain cases. So, whenever a couple is divorcing, I think one of the biggest legal questions that we face as attorneys is, what are we actually divvying up or what are we actually allocating to each party? And in terms of what qualifies as marital or non-marital property can really be a linchpin, deciding factor in many of these cases. So starting off, Reyna, can you tell us a little bit more about what actually is considered marital property in Illinois?
Yeah, of course. So first things first, obviously anything purchased during the marriage would be marital property. That includes houses, regardless of who's on the title. So even if only one party's name is on the title, that's fully marital, which I think some people get confused about. But as long as it was purchased during the marriage, both parties have an equal right to that house.
And then in terms of like a timeline for when a judge is looking at property that's marital, in your experience, does that start from the date of marriage through the date of filing, or would that be through the date of entry of a final judgment in a case?
So it starts from the date of marriage, which again is kind of hard, I think, for some people because they'll have been together for years before they get married, but you're only dividing what actually was contributed to during the marriage up until that final judgment. So anything until that final divorce decree is entered is going to be marital. That's why we always tell clients too, like, don't buy anything while a divorce is pending. Don't put anything jointly while a divorce is pending, because that is still marital property.
Right. It just, I think, blurs the line and like causes confusion. It's not as simple and straightforward if someone is going off and purchasing new things or a home or something during this process. It can definitely, I think, just further complicate and extend that process versus making it more simple. And then I also never really seen this, but even though the statute says that the judge has discretion in terms of like when they can end that property, when they can end the date that property can be acquired, it's been always my experience, like judges in Illinois wait until date of entry of final judgment. So yes, it's discretionary that they can move that or push that up. In real world practice, I don't think I've ever really seen that, or it's been in very limited circumstances. I don't know if you've had any different experience or not, but that's been kind of what I've seen.
No, definitely the same. And like I said, that's just why we caution all of our clients to keep everything separate while a divorce is pending.
Yep. And then in terms of exceptions, so I know we just hit on what is marital property or how is it defined, but are there any exceptions that exist to that, Reyna?
Yes. So gifts are one. If one party gets a gift from their parents or, someone else, that would be non-marital property. Inheritances, because, that's governed by wills and estates law versus family law. So in order for both parties to get it, it would have to be like in the will that they should both be named, like to receive that inheritance if they were both to get it. If not, it's just solely the non-marital property, that one individual.
Mm-hmm. And then are there any other exceptions for like premarital assets that maybe existed from prior to the marriage?
Yes. So, like I said, it starts counting from the date of marriage and on. So anything, that was contributed to a retirement account prior to the marriage, a house that was bought prior to the marriage, if it's solely, in one person's name, that would all be considered non-marital as long as the parties keep it separate, because then we get into the issue of commingling and it could become marital property later on.
And that's kind of the same with, inheritance or anything that existed prior to the marriage. Like how it's titled and whether it's kept separate is vital in terms of how we approach these topics. And let's just say, for example, someone did mix that. So you referenced commingling. Like what exactly does that mean? Explain that a little bit further.
Yeah. So let's say someone does get an inheritance for like $10,000, but then they used $5,000 for a down payment on a house and they put put that house, in both parties' names. And then they're using the rest of it to pay the mortgage. That's, for a marital benefit. They're using it, kind of becomes harder to track, okay, like, was this just for an individual purpose or was it for a marital purpose? And then that kind of is honestly like the question that the judges have to look at to determine if that whole 10K is still the non-marital property of the first individual.
So it's almost like when you deal with commingling or mixing of marital and non-marital assets, it just causes kind of another layer of complexity and analysis where we've got to kind of delve into that and figure out, can we trace those things? Can we trace the funds and the intent, right? Did we intend for that non-marital inheritance to get mixed into the marital estate by jointly titling that house and making payments towards a jointly held mortgage? So I think, in terms of practice, we always have to look at that and ask whether or not that adds another layer of complexity or how we analyze a case. And then, Reyna, talk about whenever we deal with, let's say, for example, a person who uses their premarital inheritance as a down payment on a jointly titled piece of property, which would be considered marital. Is there any argument that you can make, Reyna, that's creative in terms of contributions and how to maybe still try your very best to recoup that down payment in that example?
Oh, for sure. Upon divorce, you can definitely say that there should be an offset. I put in more of the down payment, so it should be split 55-45 versus just straight 50-50. Or you can ask for like a dollar for dollar reimbursement. I put down 20K of my own money. I would like my 20K back.
Mhm.
I think, again, it's kind of an uphill battle because it's all presumed marital, but I think you could still make the argument for sure.
Absolutely. And kind of getting creative with how to do that in each case, depending on like which side you're on, right? And what side you're arguing. And then can you share recent, experience that you've had where maybe a client assumed something was going to be only theirs, but it turned out that it actually was marital?
Yeah. So I think this kind of gets into the importance of like that marital intent or that purpose of what's going to remain separate and what's, going to be commingled.
Mhm.
I had a client who bought a house on his own, a few years before the parties got married. So it was solely in his name. He was solely on the mortgage. He solely put on the down payment. But after the parties remarried, they refinanced and they put both parties on the title, both parties on the mortgage, and then they were both paying off that mortgage. And so now that a divorce is happening, it was kind of a hard discussion to tell the client, I understand you bought this prior to the marriage, but because you refinanced and because they are now contributing equally to this house, again, it's a very, very uphill battle to try and say that that property is no longer marital.
And when they refinance that, adding that other individual to title, it really does transfer ownership. And I think that's where those discussions are so hard to have with someone in the example that you just provided. How difficult is it to have those, clear, upfront, frank discussions with clients to tell them, kind of to deliver that news? It's really hard, I'm assuming.
Definitely. And especially if they have like an emotional connection to the house or they're like, my kids grew up in this house. And you just have to be honest because, it's, again, we can understand, we can sympathize, but it's also our job to give them the facts, to let them know what's going to happen. And so I just try to be upfront and honest as possible from the beginning so they know what to expect. And so they know, again, like we can do our very best, but obviously we can never guarantee what a judge is going to say.
Exactly, and just try to mitigate as much as possible with either contributions or offsets like you referenced before. And I know you mentioned inheritance and gifts, so let's kind of dig in a little bit deeper with regard to that. So how does Illinois treat inheritance or gifts in terms of categorizing that type of property?
So they're kind of the opposite in that they're presumed non-marital, unless, like I said, they're titled to both parties to receive the inheritance. And then, kind of, we were saying before, as long as they're kept separate, there's no commingling, we can accurately, see or trace where the money went, then it would remain that one individual's non-marital property.
And then what would you say is the biggest mistake you see when it comes to handling inheritance in divorce cases?
Definitely, like, using it for a marital purpose, so they're putting the money in a joint account, and then they're paying the mortgage or, marital expenses from that joint account, or they're using it to make improvements on the kitchen or the bathroom. Anything that is not the sole benefit of one party, and it's, like, more of a marital benefit where both parties are using the funds, that gets very hard to track and trace, okay, when did it stop being this person's non-marital property? And then now, like, it's going to be presumed that it was for a marital purpose and therefore now marital property.
Right. And I think that goes to intent, right? And what did they intend when they used their own separate non marital inheritance towards a jointly titled house and improvements, like capital improvements, like you just referenced? I think that that just creates a really tough uphill battle to say, I didn't intend to have this benefit the marriage. I wanted it just to benefit me, especially when that house is titled jointly and, both parties are receiving that benefit. It's really tough to make those arguments or to kind of salvage that. And then let's get into tracing and documentation, because if you are going to try to salvage that type of claim, that's exactly what you need is documentation, right? And you have to be able to trace it and say, there was no intent to make these funds that were non-marital marital. So if someone is claiming that something is non-marital, like how do you prove that? What do you have to prove in terms of court to really support those types of claims?
Yeah. So the first thing I think clients need to understand is that they would have the uphill battle. They're the ones that have to show that it's non-marital. And you can do that with bank records. You can do that by looking at the title, like, again, was it titled before or after the marriage? In really complex cases, we even use forensic accountants to actually see in every little detail that was traced, which again, just becomes like a more complex, lengthy process. And again, it's really up to that individual to be able to produce those documents and show the judge that it was always supposed to be non-marital.
Definitely. And then I know you already referenced like the burden is on the person who's claiming that that property is non-marital. In terms of like contributions and offsets, how important is documentation in those instances as well?
I would say equally as important. And I think it would strengthen, if you're the person who wants your money back, again, you can be able to show at least, okay, yes, the rest of it was used for marital purposes, but that initial 20K, that was just mine. Or it was just like she was supposed to be alone, like she was supposed to pay me back, etc. Even with things like that, you should have promissory notes. You should have all these records showing that it was always supposed to be separate.
Yep, kept as your own, technically. Yeah. This was really helpful, Rena. And I think it really helps kind of our listeners understand, what's marital, what's non-marital. How do you kind of protect yourself in those instances to make sure that what you're counting on as solely yours remains that way? And, the earlier people can understand and have clarity with regard to what's marital versus non-marital, the better in terms of how they can either negotiate or plan for trial in their particular case. So thank you so much for joining us today and talking through what is defined as marital versus non-marital property in Illinois.
Thank you for having me.
Thanks, Reyna.
Well, if you think that dividing property is tricky, it gets worse when you overpay for the divorce itself, and most people do by thousands. Next up, we break down how to avoid the most common and costly mistakes in an Illinois divorce budget.